Hello again to one and all, and welcome back to the channel. I'm Charles Nathan, your friendly guide helping you to navigate the shadowy swamp that is the modern British state. As you can tell by my funky green surroundings here, this is episode 2 of Blob Watch, where I'm happy to be able to report that the High Court has in fact given the Crown Prosecution Service and the Director of Public Prosecutions a bloody nose. Despite the British state's best efforts to make him into a criminal, Mr. Hamit Koskan, our old friend, the Turkish-born atheist Quran burner, is still a free man with a clean criminal record. This is extremely important because it's going to set precedents going forward, and we'll get into them in a couple of minutes. What was interesting, there's a link there to the full High Court judgment if you want to have a look at it, but it was interesting that the court had to remind everyone that it is not their job to retry, reinterpret or relitigate cases that have already been decided. Their job is to simply see whether the lower courts have made an error either in fact or in law. And in this case, they decided that everything was in order and that the DPP's appeal should be dismissed, meaning Mr. Hamit Koskan's original appeal is upheld, and in fact his conviction for a public order offence was quashed. Now that's great news for a free, open and democratic society where people say things that you don't always like. But the state's got no business poking its nose into matters like that. What's interesting though is that the High Court did make one interesting point going forward, and I just want to pull this out because I think this has great relevance. The High Court did point out the following. It said, "The Crime and Courts Act 2013 amended sections 5 and 6 of the Public Order Act 1986 to remove the word insulting. The offence now only covers threatening or abusive words, behaviour or visible representations." The first question that came up in my non-legally trained layman's mind was, why would the High Court bother mentioning that at all? Well, a lot of observers have commented on what they see as a creeping use of the Public Order Act by both the police and the legal system to stifle completely legal and legitimate social, religious or political commentary, despite the fact that some people might find such commentary offensive or even upsetting. That's what makes this judgment so very important. And what's more, I think it might give us a clue as to why the Director of Public Prosecution, i.e. the state's representative, went so hard after a single man who stood on a nearly empty street and shouted some words that barely anyone heard. And I think maybe we're getting to the truth of the matter. Now, I'm just speculating here. I've got a hunch and time will tell if I'm right or not. But I'm beginning to wonder if the Crown Prosecution Service thought this case was so important because this was the judgment they'd always feared. I think, perhaps unwittingly, the High Court has just thrown a spanner in the works and really messed up the upcoming official definition of Islamophobia, which has been talked about but no one has yet seen. And I wonder if this has just caused a massive legal problem because the precedent has now been set. As I said, I've got no evidence at all for that. It's just a hunch, a speculation on my part, but we'll see if I'm right. Time will tell, as it always does. That's it for today. Short and sweet. As always, please like, subscribe, share, comment, do all that cool stuff. It helps small independent channels to grow and keeps independent voices vibrant on the internet. Because don't forget, our ignorance is their power. I'll see you all again soon. Bye bye for now.